So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So
Custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right? Interfaith marriages were unheard of.
Yes, that's important.
When you bring in the tradition, now the constitution itself is a tradition breaker. The constitution is a tradition breaker because for the first time you brought in
the three of us and my learned sister. Does anyone have a fundamental right to marry?
But since certain judgments
Forget the issue of same sex.
Yes.
Does anyone have a fundamental right to marry? Or is there no fundamental right to marry at all, according to you? Because your submission is that no one has a fundamental right to marry. Or is it, what is your answer to this?
My submission is simply this, my lord, that so far as heterosexual
No, we are not on heterosexual.
That's right. Keep it.
We see that's what actually triggered this idea.
Yeah.
Yes.
Does any citizen of this country for whom this court and our society and our polity has placed the individual at that highest pinnacle, and we have gone ahead and carved out or rather discovered so many rights: the right to personhood, the right of choice, the right of being left alone, the right of privacy, autonomy, which is at the core of personhood.
And dignity above all.
Dignity, which is part of our preambular promise.
Yes.
Now, with all this, what is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself is not
right
qualified.
to life is not
Can be taken away on
Therefore, we don't start with there is no unqualified right. There is no absolute right. If we start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion. And that has been continuing. That's the foundation of their right. Now that right has been...
So, but therefore you concede the fact that therefore there is a right to marry under the constitution. Sure. But that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right?
I'm saying there is a right to marry which is founded on customs, personal law, and religion. The enactments
in that case, as you taking the same argument further.
Yes.
Custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right? Interfaith marriages were unheard of.
Yes.
Right? So all this, the content of marriage has changed. Therefore, what was the fundamental right to marriage in 1954?
So these changes therefore have been brought about by legislation, and legislature can certainly alter the customs, and now the ghost of Narasu has been...
Keeping aside for a moment the legislative aspect, as you said, it's the culture, it's the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
So the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, and two people coming together and call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the constitution came in, is it your argument that the marriage was
So that right to
recognized?
marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. That's
The
right.
Constitution,
Yes.
therefore, does not grant.
It-
So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see brought was in terms of association, as we understand.
So it doesn't matter where it is located, or taking together it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which
This is the problem. The moment we qualified it in the sense, because
That's
when
important.
you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so, let me
I
just come.
appreciate.
If you brought in 14, if you brought in 19, 15, and most importantly 17, those traditions are broken.
It can be broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste? We made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say an outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. To the extent they have created the tradition, the institution of marriage, they are there. But at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, Millers. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also adverted. The point is, all these reforms which have happened are reforms, Lord, which are made by the legislatures in the interest of women and children. And they do not alter, Lord, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or the fact that some other modifications have.
Yes, you're right. That is by and large, but
but each and every reform, kindly see 1937.
We are looking at what we understand as the traditional, but there are large parts of society. It's a very diverse Hindu society. That diverse society even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes.
The diversity is there. That diversity we cannot.
Correct. So, therefore, what I submit is that the core aspect, what is the core aspect of that marriage? You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be intercaste marriages, but ultimately the marriages remained heterosexual marriages.